Welcome back to the Constitutional Clarion. This is just a quick video in response to a viewer request about the constitutional issues involved in the case called Tickle and Giggle. And yes, that actually is a real name. I am not making it up. The judgment in that particular case was handed down by the Federal Court of Australia this morning, on the day that I am recording this video. The case concerned whether it amounted to unlawful discrimination for a transgender woman to be excluded from a social media app called Giggle, which was established as a safe place for women and girls to communicate. It was claimed that this exclusion breached Section 22 of the Sex Discrimination Act, which makes unlawful any discrimination in the provision of goods, services or facilities on the ground of a person's gender identity. In response, it was argued that Section 22, to the extent that it prohibits discrimination on the ground of gender identity, is not supported by a Commonwealth head of power. It's this constitutional challenge that I'm going to address in this video, not the broader issues about sex and gender, etc., or even the discrimination issue, just the constitutional issue. While this judgment is not particularly remarkable, it is a useful illustration of what I've tried to explain in previous videos about how the Commonwealth Parliament can only legislate about subjects that are conferred upon it by the Constitution, most of which are listed in Section 51 of the Constitution. Unsurprisingly, a constitution that was written in the 1890s does not refer to gender identity. However, the Commonwealth Parliament can draw on a range of different subjects described as heads of power, which are listed in the Constitution, to make a kind of legal patchwork of powers to achieve a broader policy aim through legislation. In this case, it relied, amongst other heads of power, upon the external affairs power and the corporations power. As I mentioned in my previous video on Commonwealth heads of power, these two powers have been significantly expanded by the High Court in its interpretation of them over time. Section 9 of the Commonwealth Sex Discrimination Act recognises that it relies upon a range of different powers, and therefore it specifically limits the application of provisions of the Act to ensure their constitutional validity. Section 9, subsection 10, says that the substantive anti-discrimination provisions, which include Section 22, quote, have effect to the extent that the provisions give effect to relevant international instruments, that is, treaties. It relies upon the external affairs head of power in Section 51(29) of the Constitution, which has been interpreted by the High Court as allowing the Commonwealth Parliament to enact laws that implement treaty obligations. And on that, see my previous video about the external affairs power and treaties. The effect of Section 9, subsection 10, is that if a provision does not in fact give effect to a treaty obligation, then to that extent, it simply doesn't apply in the circumstances, unless of course it's supported by another head of power. On that point, we also have Section 9, subsection 11, which says that these substantive anti-discrimination provisions have effect in relation to discrimination by a foreign trading or financial corporation, which are the three types of corporations that fall within the corporation's power in Section 51(20) of the Constitution, or by any person who is an employee or officer of such a corporation in the exercise of their duties. Again, the issue is not one about the constitutional validity of these provisions, but rather whether the provision applies to the particular facts. For example, because the discrimination was engaged in by a trading corporation, or because the anti-discrimination provision implements a treaty obligation. So the issue is transformed from one of constitutional invalidity to one of whether the law applies or not to particular circumstances. In relation to the external affairs power, two treaties were relied on. The first was the Convention on the Elimination of All Forms of Discrimination Against Women, which is known as CEDAW. The Federal Court concluded that it didn't need to decide upon the scope of the meaning of the term women or woman in that treaty, because the treaty is directed at preventing discrimination that causes a woman to be treated less favourably than a man. Now, this is consistent with the objects set out in Article 1 of the treaty, which is directed at discrimination on the basis of sex, which has the effect of impairing the exercise by women on a basis of equality of men and women, of human rights and fundamental freedoms. As the complainant in this case was treated no differently from a man rather than less favourably than a man, the treaty did not apply. The other relevant treaty was the International Covenant on Civil and Political Rights. In Article 26, it provides that, quote, all persons are equal before the law and are entitled, without any discrimination, to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground such as race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth, or, critically, other status, unquote. This list, of course, does not refer to gender identity. However, the court noted that Article 26 includes a non-exhaustive list of the sorts of personal characteristics that are protected by the non-discrimination obligations. Gender identity is described in Section 4 of the Sex Discrimination Act as meaning, quote, gender-related identity, appearance or mannerisms, or other gender-related characteristics of a person, whether by way of medical intervention or not, with or without regard to the person's designated sex at birth, unquote. Okay, so that's the statutory definition. Now, it was argued in this case of Tickle and Giggle that this definition was too nebulous and changeable to amount to the kind of status that's referred to under Article 26 of the treaty. The court, however, noted that the category of political or other opinion, which is also included in Article 26, is not a reference to some kind of immutable or biologically founded characteristic, but one that can change across an individual's life. And therefore, those categories in Article 26 can't be seen to be bound in that particular way. So should gender identity be interpreted as included in the category of other status in Article 26 of the treaty? On the one hand, when the treaty was made in 1979, it probably was not considered to be a relevant status, and it certainly wasn't listed as such in the treaty. So if one relied upon original intent as the means of interpretation, then the answer might be no. But on the other hand, the wording of Article 26 was deliberately kept broad to allow other statuses to be included, showing an original intent for it to expand over time. The factor that persuaded the Federal Court, however, was that the United Nations Human Rights Committee, which is the one that's empowered to hear complaints about violations under the treaty, had accepted that gender identity is an other status for the purposes of Article 26. The list of examples of when this occurred is set out in the judgment, and those examples range from 2012 to 2023. The Federal Court held that Article 26 created an obligation for parties to the Convention to prohibit discrimination on a number of grounds which, quote, may readily extend to gender identity, unquote. This then provided the treaty obligation, which triggers the application of the External Affairs power to support the relevant provisions of the Sex Discrimination Act that address gender identity. So that's how the train of reasoning works out. The Federal Court also found that Giggle for Girls Proprietary Limited, which operated the app, was a proprietary company limited by shares and was also a trading corporation within the meaning of Section 5120 of the Constitution. Accordingly, it and its officers and employees were obliged under Section 22 of the Sex Discrimination Act not to engage in discrimination in the provision of goods and services on the basis of gender identity. The test was whether Giggle's trading activities formed a sufficiently significant proportion of its overall activities to be characterised as a trading corporation. The mere fact that its primary purpose was non-trading, providing a safe place for communication amongst women and girls, was of itself not sufficient. Giggle offered users premium upgrades for a fee, and it also showed advertisements. It was also intended that it would provide a return on investment for its investors. Even though Giggle proved not to be profitable, the court found that a purpose of Giggle was to turn a profit through trading activities, if only to support its continued existence. This in itself was, according to the Federal Court, enough to make it a trading corporation. The upshot was that Section 22 of the Sex Discrimination Act 1984, which makes it unlawful to discriminate against a person on the ground of gender identity when providing goods or services or making facilities available, applied to Giggle, both because it was a trading corporation and because the law implemented an obligation under the International Covenant on Civil and Political Rights. Now, this is a good example of the patchwork nature of the application of Commonwealth heads of power and how those powers extend today to matters that could scarcely have been imagined in the 1890s. I hope that clarified for you the constitutional issues in the case. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.